My name is Doug Bonsall. I am the Director of HR here in Brownwood ISD. We are going to spend the next few minutes discussing the new Title IX regulations that were issued by the United States Department of Education back in May of this year. The new requirements significantly alter a response a school district has to complaints of sexual harassment, and every Brownwood ISD employee must go through this training. So we're going to spend the next few minutes covering the changes to Title IX reporting and the responses that we must give as a school district and or school. Let's take a moment and look what exactly is Title IX. Title IX is a federal civil rights law that was passed back in 1972 to prohibit sex discrimination in educational institutions and provide remedies against such discrimination. It states, no person in the U.S. shall on the basis of sex be excluded from participation in, be denied the benefits of, or be subject to discrimination under any education program or activity receiving federal financial assistance. What is the purpose of Title IX? Title IX protects students and employees from discrimination on the basis of sex in educational programs and activities, including sexual harassment. However, until recently, neither the Title IX statutory language nor its implementing regulation explicitly referred to these protections. So the new regulations came out of the Department of Education on May 6th. They went into effect in August. The new rules now include a very specific process for schools when responding to allegation or reports of sexual harassment, and the rules require all employees to be trained on the new regulation, which is what we're doing through this presentation. So why are the new Title IX regulations important to you as an employee of Brownwood ISD? It affects all of you. It is important for you to understand your role as an employee so that we can ensure our students and employees are protected from sexual harassment in the education environment. So let's take a moment and talk about what is sexual harassment under Title IX. There are three categories of conduct that fall under the definition. They are quid pro quo, hostile environment, and then you get into the actual sexual assault, dating violence, stalking, and domestic violence. So let's look specifically at quid pro quo. Quid pro quo is when an employee, a school employee, conditions access to an educational benefit on unwelcome sexual conduct. That school employee may cause a student to believe that he or she must submit to unwelcome sexual conduct in order to participate in an activity, get a grade, etc. An employee may cause a student to believe that the employee will make an educational decision based on whether or not the student submits to the unwelcome sexual conduct. And the example there at the bottom of the slide, for example, a teacher threatens to fail a student unless the student agrees to date the teacher or go out on some type of social dating environment. So now let's look at hostile environment under the sexual harassment umbrella under Title IX. Hostile environment would be any unwelcome conduct that a reasonable person would determine is so severe, pervasive, and objectively offensive that it effectively denies a person equal access to an education program or activity. It can be created by a student, it can be created by an employee, someone visiting the school, a contracted worker, anyone. Examples: sex or gender-based bullying, like abusive, intimidating comments or actions; continual offensive comments such as jokes, where the environment becomes very sexual in nature; whistles, cat calls, if you don't know what that is, like if you scream at somebody, innuendos, sexual innuendos, and any type of inappropriate touching would fall under the hostile environment definition. The new definitions also incorporate four components into the sexual harassment definition under Title IX. First, sexual assault. An offense classified as a forcible or non-forcible sex offense. Dating violence. Violence committed by a person who is or has been in some type of social relationship of a romantic or intimate nature with the victim. Domestic violence. That violent or aggressive behavior within the home, typically involving the violent abuse of a spouse or partner. And then the fourth one, which is kind of interesting, stalking, which is engaging in a course of conduct directed at a specific person that would cause a reasonable person to fear for his or her safety or the safety of others due or suffer substantial emotional distress due to that behavior. So now let's look at some other definitions. They're pretty straightforward. Complainant, an individual who's alleged to be the victim. Respondent, an individual has been reported to be the perpetrator of the conduct that could constitute sexual harassment under Title IX. And obviously, a recipient is the school district or the entity that is receiving federal funds. That would be the school or the district in total. So when must we as educators respond to allegation of sexual harassment? A school must respond when it has actual knowledge of sexual harassment that occurred within the school's educational program or activity. How do you determine if you have actual knowledge? Here's the definition. Any employee of a school has notice of sexual harassment, so somebody informed you, therefore you have actual knowledge of any allegation of sexual harassment. This includes teachers, aides, drivers, operational employees such as cafeteria workers, school counselors, your school resource officer, maintenance staff, workers. It literally includes, when we say all, in that very next statement on the slide, this means you. So if you are watching this video and you receive a report of something that could be a Title IX violation under the sexual harassment umbrella that we have talked about, you must report. The school district may be held liable if an employee has notice of sexual harassment or allegations and the employee fails to report it. All employees must report instances of sexual harassment or allegations of sexual harassment. So what do we specifically mean by education program or activity? The sexual harassment must occur within the school's educational program or activities in the United States. So if we were on some type of trip overseas, this situation would not apply. However, this does include events or circumstances of which the school exercises substantial control. The alleged perpetrator and the context in which the sexual harassment occurs. So that would include things such as homecoming dances, areas where we may have a parent night, something where the school is exercising oversight, control of that event, then we are under this umbrella relative to reporting any type of Title IX sexual harassment violation. It also includes any type of unlawful harassment involving students or employees which occurs at school facilities, on a school bus, class, or activity sponsored by the school at another location. So a field trip, an athletic trip, a fine arts trip, a fine arts event at another school. All of those events fall under the requirement for you as an employee, if you get a report or witness something, to report. So if you get a report, who should you refer or report the Title IX sexual harassment violation to? An employee should report information regarding allegations of sex-based discrimination, including sexual harassment of a student or employee, to campus or district administration or the district Title IX coordinator, who is me, Doug Bonsall, the director of HR. Reports can be made anytime to these people. And again, they're listed there for you. If you have any report of any type of sexual misconduct or sexual harassment, you must report the incident immediately. Again, this slide is reiterating who you can make that report to. You can make it again to an administrator within the district, whether it be campus or district level, or you may contact me directly at my phone number 325-643-5644, extension 1117, and my email doug.bonsall@brownwoodisd.org. When the district gets a report or a complaint relative to sexual harassment, we are required to respond promptly in a way that does not demonstrate any type of deliberate indifference. When you look at what the definition of deliberate indifference is, it means the response was clearly unreasonable in light of the known circumstances, which means you know, or we knew of the potential violation of sexual harassment guidelines under Title IX, and we did not act in a manner that was appropriate to the situation. Deliberate indifference is when you do not react quickly, promptly, and appropriately to what has been reported. Once a report of sexual harassment is reported, I, as the Title IX coordinator, will promptly contact the complainant, the alleged victim, and we'll discuss the process of what we're going to do. We will discuss any type of supportive measures that alleged victim might need. We will discuss in detail their right to file a formal complaint and the process for filing that complaint if they choose to do so. And then we will discuss the grievance process if the determinations or if the process does not go as they think is best. If a formal complaint is not filed, we may still investigate as a district and respond in accordance with our policies, code of conduct, etc. Lastly, very straightforward, I need you to remember that sexual harassment between students, employees, between students and employees, between employees and students is illegal, prohibited by law and board policy. Let me reiterate again, report all allegations of sexual harassment to your campus or district administrator or me, the Title IX coordinator. Thank you.